Thank you. We will now restart proceedings, and we will proceed with division on amendment number 6. Members should cast their vote now. The vote is now closed. Point of order, Jenny Ruth.
My app would not connect, Presiding Officer. I would have voted no.
Thank you, Ms Ruth. Your vote will be recorded. Thank you. The result of the vote on amendment number 6 in the name of Maggie Chapman is yes 14, no 102. There were no abstentions. The amendment is therefore not agreed. We now move to Group 2, process following receipt of parental withdrawal request. I call amendment 1 in the name of Stephen Kerr, grouped with amendments 2, 3, 4, 5 and 19. I point out that if amendment 19 is agreed to, I cannot call amendment 20 to be debated in group people's rights to withdraw from religious observance due to a preemption. I call on Stephen Kerr to move Amendment 1 and speak to other amendments in the group. Mr Kerr.
For clarification, Presiding Officer, what I said to Maggie Chapman in the context of my remarks was that applying secular analytical frameworks to something that is not designed to function in that way is not a small drafting point. It is a conceptual mistake, which is my polite way of saying I don't think it's understood. This Group 2 goes to the heart of how this legislation will operate in practice. Section 9A of the 1980 Act is inserted in this bill, establishes a formal process once a parent requests withdrawal from religious observance. That framework is now set clearly out clearly in the amended bill, and it requires operators to inform the pupil, invite their views, and if the pupil objects, to refuse the parental request. Now, that is a significant constitutional and educational shift. It alters the balance between parental authority, institutional responsibility, and the child's developing autonomy. My amendments do not seek to undo that framework. They seek to ensure that it is workable, legally coherent, and fair in its consequences. Amendment 1 addresses an issue that should concern every member of this Parliament. What actually happens to the child once withdrawal takes place? If we are going to formalise a process in which some pupils are withdrawn from religious observance, then the statute must guarantee that those pupils are not educationally sidelined. The bill currently protects against disadvantage in terms of secular instruction, but it does not explicitly guarantee purposeful alternative activity during the period of withdrawal. Amendment 1, therefore, places a clear statutory duty on the authority or managers to provide suitable and purposeful educational activity. Amendments 2, 3 and 4 turn to the question of maturity and capacity. As drafted, Section 9A presumes that a pupil is capable of forming a view unless the contrary is shown. In abstract terms, that sounds child-centred. In practical terms, it places schools in a difficult and potentially adversarial position. The bill now creates a process in which, if a pupil objects, the parental request must not be given effect. That is not simply consultation. It is determinative. In such circumstances, Parliament must be precise about thresholds. Amendment 2 clarifies that it is a pupil of age 16 or older whose position carries that determinative weight. I give way to John Mason.
Speaking, interestingly, as one religious member to another, does he not think that 16 is a bit on the high side? I mean, I would have accepted if he'd said, at secondary 1A stage or maybe somewhere in between. But 16, 16 will allow young people to do a lot of things. Surely, below 16, they should be able to opt out of religious observance.
Stephen Kerr.
Actually, John Mason makes my point for me. 16 is not an arbitrary number. In Scots law, it marks a recognised threshold of legal capacity. It is the age at which young people acquire significant rights and responsibilities. I give way to Alec Cole-Hamilton.
Alec Cole-Hamilton.
I'm very grateful to the member for giving way. I have pushed my button to speak in this group on this particular issue because we have a range of ages of majority in this, as laid out by this Parliament. At the age of 12, your medical consent is sought. You're deemed to have capacity over medical decisions made about your body. The age of criminal responsibility is much lower than 16. It's something, actually, that the Conservatives have resisted an increase in. So I would ask Stephen Kerr to explain these inconsistencies to the Parliament as to why he's bringing this one.
Stephen Kerr.
Alec Cole-Hamilton's asking me to explain the inconsistencies of legislation that this Parliament is responsible for. I would like there to be less inconsistency in these areas. Unfortunately, we live with these inconsistencies, and that is why I'm bringing forward this particular amendment, Amendment 2, to set 16 as the age. I recognise what Alec Cole-Hamilton says, and I sympathise with his point of view about the confusion there is around these matters. I wish there was some clarity. I give way to Maggie Chapman.
Maggie Chapman.
I thank Stephen Kerr for taking my intervention. I wonder whether he would be able to tell the Chamber whether he thinks that children under the age of 16 can make any decisions for themselves and therefore would be considered to have capacity in this regard. Because what the UNCRC is quite clear about, something that his party has agreed to, what the UNCRC is quite clear about is that children and young people should be assumed to have capacity unless it is proven otherwise. The bill as it stands is consistent with that. His amendments would put the bill at odds with that principle.
Stephen Kerr.
Well, Maggie Chapman is asking me whether I believe that children under the age of 16 can make their own decisions. Well, as the father of 4 children, I can assure members that children do have the capacity, in many instances, to make decisions for themselves. This happens to fall under an area covered by the 1980 Act that I believe deserves our careful scrutiny. I do believe that in Scots law, the age of 16 is a recognised legal threshold in terms of capacity. It's an age at which young people acquire, as I said a moment ago, significant rights and responsibilities under law. That's not the same as the question that Maggie Chapman asked me. Now, aligning the bill with existing legal architecture is not restrictive. It is coherent. And I move to Amendment 3, which replaces the phrase capable of forming with have the maturity to form. And that shift is deliberate. Capability suggests a minimum cognitive ability. Maturity recognises emotional development, contextual understanding and the capacity to appreciate consequences. It's not semantic refinement, it's a more accurate articulation of what Parliament must mean if the child's view is to override the parent's statutory right. I give way to Martin Whitfield.
Martin Whitfield.
I'm very grateful to the member giving way. Is he actually not shifting from an objective assessment to a subjective assessment with a move from capable of forming to having the maturity? And what you're doing is what the member is seeking to do is shift the judge on who decides that.
Stephen Kerr.
Well, the issue of the maturity, the emotional development of a child is an ongoing subjective decision. That is reviewed continually in the light of their development, which is highly individual, as I know Martin Whitfield will know only too well. But I think it's important that we have clarity around the articulation of what Parliament means. Particularly, and I repeat this point because it's so important, if a child's view is to override a parent's statutory right. That is what this bill would put in effect. And therefore, this requires this careful scrutiny of this amendment at this stage in the bill's progress. Amendment 4 then establishes a presumption that a pupil under the age of 16 is not to be treated as having the maturity to form such a view unless the contrary is shown. That is not a blanket exclusion. It preserves flexibility. Where a younger child demonstrates demonstrably possesses unusual maturity, the presumption can be rebutted, but it prevents the default position from becoming automatic opposition to the parent's request. And that's the whole point of this bill. And throughout the scrutiny of this bill, I have emphasised that the UNCRC speaks of evolving capacities. It doesn't erase parental responsibility. Article 5 recognises the responsibilities, rights and duties of parents to provide appropriate direction and guidance. And if this legislation is to claim UNCRC alignment, it must respect that dual principle. And these amendments restore balance without denying the child's voice. Amendment 5 is equally fundamental. It requires that operators act impartially and do not seek to influence the pupil's views. If the school is required to inform the pupil of the request and of the right to object, that communication must be neutral. It must not be framed in a way that steers the pupil towards objection, nor should it minimise the seriousness of the parental decision. Schools are trusted institutions. Parents must have confidence that they are not entering a process in which their child will be subtly encouraged to contradict them. Without explicit statutory impartiality, we risk creating a dynamic in which the school becomes an active participant in a dispute rather than an honest broker. And that would be unfair to families and unfair to teachers. And against that background, I have serious reservations about Amendment 19. On its face, a statutory duty to issue guidance on the withdrawal process may appear sensible, but we are being asked to endorse guidance we have not seen in an area that already places teachers in a sensitive and potentially invidious position. Guidance can clarify, it can also expand expectation and reshape practice. If this bill already formalises a process that many believe goes further than necessary, layering additional statutory guidance without clear parameters risks compounding that shift. Teachers are educators. They should not be routinely drawn into adjudicating family disagreement on matters of conscience before granting ministers further influence over how this delicate process is conducted. Parliament should be confident that such guidance will reinforce restraint, not extend intervention. So in conclusion, these amendments are principled, they are carefully framed, they respect children's voices while preserving parental responsibility. They provide schools with clearer statutory guidance and reduce the risk of inconsistent application across Scotland. And if we are to legislate in this sensitive space of conscience, family life and education, we must do so with seriousness and balance. And these amendments help us do that exactly. And I commend them to Parliament.
I call Elena Whittam to speak to Amendment 19 and other amendments in the group. Ms Whittam.
Thank you, Presiding Officer. I move Amendment 19 in my name. Amendment 19 addresses the calls from a number of stakeholders for clear guidance on the implementation of the changes proposed in Part 1 of the bill. Amendment 19 would therefore change the existing ministerial power to issue statutory guidance into a duty to do so. It also introduces further requirements related to the content of that guidance, the consultation process that must underpin its development, and the arrangements for its publication. The amendment sets out the core areas that the statutory guidance must cover. These reflect a number of the issues raised during Stage 2 and include the process for considering a request for withdrawal from religious observance, support available to pupils and parents during this process, assessing whether a pupil is capable of forming a view about a request, and handling of discussion between pupils and parents about said request. It also establishes a list of mandatory consultees that ministers must engage with when preparing this guidance. Finally, Amendment 19 sets out a clear timescale within which Scottish ministers must issue the guidance, stipulating that the guidance must be published within a year of the commencement of the relevant provisions to prevent delays in providing this much-needed clarity for schools, pupils and parents. Thank you.
Thank you, Ms Whittam. I now call Paul O'Kane.
Thank you very much, Deputy Presiding Officer. Just briefly on amendments within this group, in particular those in the name of Elena Witham. Given the significant changes that are being brought by this bill and the new position this puts schools in to effectively have to perhaps arbitrate between parents and children on issues of faith or conscience, things that are deeply personal and private very often, I think it is important that schools are given clear guidance on how processes within the bill would operate, and I think that that has to be done within a timely manner. So, therefore, I think the detail behind that amendment and the commitment to its production in short order will be key. So I think it's just worth putting that in the record. And I think the whole Chamber will welcome seeing a final version of it. Thank you.
Thank you, Mr O'Kane. I call Pam Gozo.
Thank you, Presiding Officer. I have raised several concerns regarding the children withdrawal from religious education and amendment of UNCRC compatibility duty Scotland Bill in committee at stage 1, in the stage 2 amendments and while meeting with the Cabinet Secretary. I would like to put on record that the issues of concern are the possibility of parents being overruled and increased pressures on teachers, the danger of precedent being set. For example, we have already seen controversial organisations such as LGBT Youth Scotland entering schools, including primary schools, to deliver material that many parents believe advance a political agenda. That being said, I welcome the meeting with the Cabinet Secretary last month. Even though this did not lessen any of my concerns, I was pleased to hear that the guidance will be issued which will cover issues such as the age of legal capacity and how conflict between parents and pupils will be managed. However, Presiding Officer, as we all know too well, the devil is in the detail. And as we have not seen this guidance, I cannot support this bill. That being said, I welcome amendments from my colleague Stephen Kerr, which include vital safeguards, including recognition that pupils under 16 may lack the maturity to form an informed view.
I think Ms Gozo has finished her contribution. At this point, I now call Alex Coe-Hamilton.
Thank you very much indeed, Presiding Officer. As I hinted to Stephen Kerr in my intervention in his remarks, I rise primarily just to speak to Amendment 2 in respect of Stephen Kerr's attempt to introduce an age of 16 as a presumption of maturity in making decisions in this matter. I mean, Stephen Kerr freely admits that we are inconsistent as a Parliament and as a country on the age at which we recognise maturity and offer autonomy to our children and young people. And that has come from a very considered space in some regards. Around health, for example, was an example I raised at the age of 12, at which you make your consent will be sought for medical processes and procedures. The age of criminal responsibility in this country was raised by legislation in the last Parliament to 12. I had amendments to raise it higher, to 14 and to 16 respectively, but it was in large part down to his party that this Parliament rejected both and leave us still with an age of criminal age of responsibility which is lower than Russia and China. For the age of criminal responsibility, the Conservatives in that piece of legislation attested that this was about understanding right from wrong. Understanding right from wrong. Surely, Presiding Officer, the assessment of... I will give way in a minute. I just want to make this point. That understanding right and wrong, what sits well with your conscience, is absolutely at the heart of this debate today. That we can't, on the one hand, afford young people the recognition of their maturity to know the difference between right and wrong, or what sits well with their conscience when it comes to criminal acts, but not allow them that same recognition for what sits right with their conscience when it comes to matters of faith, I think is a fundamental inconsistency. And for that reason, I believe that Stephen Kerr's amendment is fundamentally flawed. But I will give way to Stephen Kerr.
Col Hamilton in making the point about the inconsistencies. I respect that point of view. I do think there are a variety of different ages that we have to conjure with. But does he not accept the issue here is a matter of family life and the rights and responsibilities of parents? That surely should have a different shade on this matter than simply the approach he's taking.
Alex Hamilton.
Well, Presiding Officer, I welcome the intervention from Stephen Kerr because it's important, I think, to the very heart of this debate. And yes, there will always be tensions of rights between groups in our societies. And in this case, we're talking about the tensions of rights as a parent and the tensions as they exist in rights of the child. But this Parliament, with unanimity, has passed our commitment to incorporate the United Nations Convention on the Rights of the Child into Scots law. His own party voted unanimously in favour of that. I will give way on that point.
Stephen Kerr.
I made it clear within my remarks that the UNCRC recognises the roles and responsibilities of parents and the evolving nature of the autonomy of a child.
Alex Hamilton.
But the UNCRC offers us a blueprint as to how to navigate the tensions in those rights. And actually, everything in this bill, I think, actually helps us with our compatibility towards the UNCRC. So I don't accept that raising the age at which children can be afforded the agency to make decisions on this matter to 16 somehow will ameliorate the tensions in those rights. Presiding Officer, this comes back to conscience, about what sits right with your conscience. And if we, as a Parliament, and I would it were otherwise when it comes to the age of criminal responsibility, recognise and afford children the maturity to make decisions on what's right and wrong when it comes to criminal acts at the age of 12, I do not see why we should suggest that they don't have an ability to say what sits right with their conscience when it comes to matters of faith. Thank you.
Thank you, Mr. Hamilton. And I call Graham Simpson.
Yeah, many thanks. I hate to say this to Stephen Kerr, but he's got some of this wrong. I think on the issue of age and the age at which children are able to form a view, it's just not right to put a hard and fast figure on it, certainly not the age of 16. And I can actually remember when I was at school, I'm sure Mr Kerr can as well, and I know there were pupils aged less than 16 who were perfectly capable of forming a view on this issue, and I'm sure, yes, of course.
Stephen Kerr.
Does Graham Simpson accept and understand in the context of this bill, we're also talking about the rights and responsibilities of parents? Surely, as a Parliament, we understand and accept that parents have an important role in the lives of their children until they reach this legal threshold. To set them aside, I think, is a very bold thing to do, as this legislation does, and that's why I am testing this Parliament's view on this matter, and indeed testing Graham Simpson's view on this matter.
Graham Simpson?
Where are parents?
Well, Stephen Kerr doesn't need to test my view. I'm looking at the amendments in front of us, which don't mention parents. I accept that parents are part of the debate, which we'll have. I mean, Stephen Kerr is chuntering from a sedentary position, but we need to be looking at the amendments that are actually in front of us. Yes, I will.
Stephen Kerr.
When I can stand up and say, but the whole point of these amendments is to underscore the importance of the roles and responsibilities that parents have for their children. That is why I made that clear. I think I could not be clearer about why I'm introducing these amendments and what the intention is behind them. It's to reinforce family life and the roles and responsibilities of parents.
Graham Simpson.
Unfortunately for Stephen Kerr, if you look at Amendment 3, the wording is be capable of forming, have the maturity to form. Amendment 4, a pupil under 16 years of age is presumed not to have the maturity to form a view unless the contrary is shown. Now, that's just wrong, because there are many, many children under the age of 16 who are perfectly capable of forming a view. Where I've got good news for Stephen Kerr, though he might not bother him one way or the other, is Amendment 1, which I think is extremely sensible, where a pupil is withdrawn from religious observance. We must ensure that there is some kind of purposeful education activity during that period. So I can support him on that, but not the others, and I will support Elena Whittam's Amendment 19.
Thank you, Mr Simpson. I would advise members that they will probably note that we will shortly reach the next time limit, and we still have a further group still to debate within this scheduled time limit. As a consequence, under Rule 9.8.5a, I am minded to accept a motion without notice to propose that the time limit be extended by 30 minutes. Could the CABSEC please move that motion formally?
Moved, Presiding Officer.
Thank you. The question is that the time limit for debate on amendments be extended by 30 minutes. Are we all agreed?
Yes.
Thank you. I now call the Cabinet Secretary.
Presiding Officer, as we have heard, Stephen Kerr's Amendment 1 would require schools to ensure suitable and purposeful educational activity is provided for any pupil who is withdrawn from religious observance. The amendment is consistent with the Government's existing guidance on religious observance, which outlines that schools should provide worthwhile alternative activities for pupils who are withdrawn from religious observance. And for those reasons, like Mr Simpson, I am able to support Amendment 1, and I would encourage members to do so. Amendments 2, 3 and 4, also in the name of Mr Kerr, would, however, significantly alter the bill's approach to how pupils are involved in decisions about withdrawal from religious observance. Taken together, they would remove the presumption that pupils under 16 should have their views considered in relation to a withdrawal request. They would be presumed not to have maturity to form a view on their withdrawal unless the contrary is shown. Now, that would effectively introduce an age-based threshold of 16 for the new pupil rights in the bill, which goes against existing legislation and children's rights, as I think we've already heard this afternoon. Amendment 3 specifically shifts the test for whether a pupil can express a view from one based on capacity to one based on maturity, and in doing so, the amendment does not align with the requirements of Article 12 of the UNCRC and also conflicts with the wording in Section 9A3, which refers to a pupil's capability to form a view. This creates a level of confusion about the judgment required from the operator without any clear benefit. Presiding Officer, the bill as it stands includes a presumption that a child is capable of forming a view unless the contrary is shown. This reflects the concept of evolving capacities under the UNCRC and also aligns with established legislative precedents, including the UNCRC Incorporation Act 2024. This capacity-based approach was supported by a majority of committee members in the Stage 1 report. So for those reasons, I am not able to support Amendments 2, 3 and 4. Stephen Kerr's Amendment 5 would require school operators to act impartially and not to seek to influence a pupil's views in relation to parental withdrawal requests. And while a similar amendment on this issue at Stage 2 was lodged by Stephen Kerr, was phrased in such a way that it implied a lack of professionalism in schools, I welcome the more careful framing of this amendment. It provides reassurance without undermining trust in teachers. I am therefore happy to support Amendment 5. Amendment 19, in the name of Eleanor Whittam, would replace the existing ministerial power to issue statutory guidance with a duty to do so. It also sets out additional requirements regarding the content of that guidance, as we have heard, the consultation that must take place during its development and the arrangements for its publication. This amendment... Happy to Whitfield.
I'm very grateful for the Cabinet Secretary taking intervention. Does she envisage in subparagraph 2 sentences A and D, process for considering the request, but handling of a discussion between pupil and parents would be sensitive to what is actually happening in that case, which is a balancing of two different rights being arbitrated by another person? Is it in that guidance that the Cabinet Secretary feels advice would be given on to how to best handle that balance? Cabinet Secretary.
Envisage that those discussions would be sensitive to that difference of opinion, very much so, to give the member assurance on that point. I think we've heard a range of views in relation to the development of the guidance this afternoon, but it is important to say that the 12-month period will begin pending the passage of the legislation, Presiding Officer, with consultation with the mandatory consultees. That is imperative, and I think we've heard some arguments from the members' colleagues in relation to why that is important in recognising the difference that exists in our schools, but also in reflecting that in the statutory guidance. I mentioned, Presiding Officer, school operators and, of course, education authorities and the managers of grant-aided schools, as well as bodies representing teachers, parents and children and young people, are part of those mandatory consultees that I spoke to in response to Mr Whitfield. As with Amendment 21 in the previous group, it also includes representatives of denominational schools, recognising their distinct interests and the importance of consulting the denominational sector, as again we heard in the previous group. Finally, it places a time requirement on ministers to publish the guidance. Amendment 19 responds constructively to the committee's discussion at stage 2, and it offers a helpful and a proportionate set of requirements for the statutory guidance. For these reasons, I support Amendment 19. The Government is happy to support Amendments 1, 5 and 19, and I would ask Stephen Kerr not to press Amendments 2, 3 and 4.
Thank you, Cabinet Secretary. I now call on Stephen Kerr to wind up and to press or withdraw Amendment 1. Mr Kerr.
Well, President Officer, I'm very grateful to the Cabinet Secretary for accepting Amendments 1 and 5. That's a most pleasant surprise on this Tuesday afternoon. And grateful for the spirit with which the Cabinet Secretary has approached the intent of and indeed the detail of these amendments. I remain, indeed I think on this side of the chamber, we remain concerned about the rights of parents. I thought Martin Whittenfield's intervention on the Cabinet Secretary captured it well. There is a tension here between the rights of the child and the rights of parents. And above all else, I think our concern is for family life. And I believe that this measure has the potential to create difficulties in that area, forcing institutions like schools and indeed school teachers in general, and school leaders into an unenviable position where they really can't win. But I'm grateful for the acceptance of Amendments 1 and 5. Amendment 19, again, I understand the intent of Amendment 19, Presiding Officer, but I am really concerned about the fact that we don't have any kind of idea around the drafting even. I understand about the degree to which there will be consultation, but before that consultation there would have to be something to consult over. I would like to have seen what the thoughts are around what that guidance would be, and I feel very concerned. I think Pam Gossel said it well. I mean, I think very concerned about what exactly that would entail, given the power that this guidance could have in terms of shaping practice in our schools. And on that basis, I will conclude by moving Amendment 1.
Thank you, Mr Kerr. The question is that Amendment 1 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, David Torrance.
Thank you, Presiding Officer. My app couldn't connect to the app. I would have voted yes.
Thank you, Mr Torrance. Your vote will be recorded. The result of the vote on Amendment number 1 in the name of Stephen Kerr is yes 99, no 0, abstentions 19. The amendment is therefore agreed. I call Amendment 2 in the name of Stephen Kerr, ready to debate with Amendment 1. Stephen Kerr, to move or not move?
Moved.
Moved. The question is Amendment 2 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, David Torrance.
Thank you, Presiding Officer. Still couldn't connect to that. I would have voted no.
Thank you, Mr Torrance. Your vote will be recorded. The result of the vote on amendment number 2 in the name of Stephen Kerr is yes 26, no 91. There were no abstentions. The amendment is therefore not agreed. I now call Amendment 3 in the name of Stephen Kerr. Rise to debate with Amendment 1. Stephen Kerr to move or not move?
Moved.
Moved. The question is that Amendment 3 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Angus Robertson.
Apologies, Presiding Officer, I couldn't connect. I would have voted no.
Thank you, Mr Robertson. Your vote will be recorded. Point of order, David Torrance.
I would have voted no, Presiding Officer.
Thank you, Mr Torrance. Your vote will be recorded. The result of the vote on amendment number 3 in the name of Stephen Kerr is yes 26, no 72. There were 19 abstentions. The amendment is therefore not agreed. I call amendment 4 in the name of Stephen Kerr. Rise with amendment 1. Stephen Kerr to move or not move?
Moved.
Moved. The question is that amendment 4 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, David Torrance.
Thank you, Presiding Officer. I would have voted no.
Thank you, Mr Torrance. Your vote will be recorded. The result of the vote on amendment number 4 in the name of Stephen Kerr is yes 25, no 92. There were no abstentions. The amendment is therefore not agreed. I call amendment 5 in the name of Stephen Kerr. Rise to debate with amendment 1. Stephen Kerr to move or not move?
Moved.
Moved. The question is that amendment 5 be agreed to. Are we all agreed?
Yes.
Are we all agreed?
Yes.
The Parliament is agreed. I understand Alex Hamilton wishes to make a point of order.
Thank you very much, Presiding Officer. At the top of my remarks, I should have declared an interest in that my wife is a primary school teacher in a Roman Catholic primary school.
Thank you, Mr Hamilton. That will be noted on the record. We now turn to Group 3, People's Right to Withdraw from Religious Observance. I call Amendment 16 in the name of Maggie Chapman. Group with Amendments 17, 18, 20, 7, 7A and 9. I point out that if Amendment 19, previously debated in Group process following receipt of parental withdrawal request, is agreed to, I cannot call Amendment 20 due to a preemption. And I call on Maggie Chapman to move Amendment 16 and to speak to other members of the group. Ms Chapman.
Thank you, Presiding Officer. The child-facing version of the United Nations Convention on the Rights of the Child says, and I quote, "I have the right to be listened to and taken seriously." However, the 1980 Act allows children to be withdrawn from religious activities in schools without their consent and without even taking their views into account. This is clearly contrary to the Convention, and I welcome the bill's opportunity to correct that. As it stands, however, the bill allows a young person to opt back in if they have been opted out of those activities by their parents or guardians, but not to opt out themselves. That directly contradicts the Scottish Government's draft child rights scheme, which says that it wants to give children, and again I quote, the knowledge and confidence to use their rights. That suggests, rightly, that children should be able to use their rights proactively and not only after an adult has acted on their behalf. The bill goes against the advice of the Children and Young People's Commissioner, Scotland, who was explicit in her letter to the committee, in which he said, and I quote, "Part 1 in its current form does not achieve compliance with the UNCRC." Her view is shared by others. The committee Stage 1 report also notes that, and I quote, "a majority supported amending the bill to provide children with an independent right to withdraw from religious observance." End quote. That majority includes not only more than one party, two parties on that committee, but also the Scottish Human Rights Commission and together the Scottish Alliance for Children's Rights. Professor Angela O'Hagan of the Scottish Human Rights Commissioner told the committee that without such a right, the bill would fail to meet its basic aim of achieving compliance with UNCRC. In its 2023 concluding observations on the rights of the child in the UK, the United Nations also called for withdrawal requests by children and young people not to be subjected to parental consent. If all that was not enough, a Salvation poll commissioned by the Humanist Society Scotland shows that 66% of Scots believe that pupils should be able to decide for themselves whether to take part in religious observance. And colleagues across this chamber make up the majority of supporters of every political party. They may be interested to know that their members, their supporters, agree too. It is central to the whole notion of the rights of children and young people that they should not be a subsidiary to the actions of adults. Children should be empowered to exercise their own rights independently. By allowing young people to override their parents' wishes but not proactively exercise their own rights, this bill undermines a central purpose to strengthen those fundamental rights to be heard, taken seriously and listened to. My amendments in this group allow us to correct that. Amendment 17 and 7 do that in different ways. Amendment 17 and its consequentials, 16, 18 and 20, put an independent right to withdraw directly into law, on the face of the bill, very, very clearly, understanding that children should have that right. As a weaker alternative, Amendment 7 and consequential Amendment 9 empower the Scottish Government to do so via regulations, whilst 7A requires those regulations to be developed. I understand that the Scottish Government is minded to support Amendment 7, but I don't think this is enough. If they cannot also support 7A, I would ask the Cabinet Secretary to address in her speech or intervene on me now to say that the Government will commit to consulting on the regulations if they lead the next Government. The Cabinet Secretary knows how important an independent right to withdraw from religious observance is to the Scottish Greens being able to support this bill. Presiding Officer, the amendments in this group are fundamentally about giving children the powers to exercise their rights. The Scottish Human Rights Commission says we should do this. The Children and Young People's Commission Scotland say we should do this. The United Nations says we should do this. Let's do this. Thank you.
Thank you. And I now call Jeremy Balfour.
Thank you, Deputy Presiding Officer. I wish to speak against Amendments 16, 17 and 7 together because taken as a whole, they represent a serious shift in the balance of authority between parent-child and the state. At the heart of this is the question of responsibility. Who decides when it comes to a child's religious upbringing and who carries the authority to see that decision through? Amendment 16 may look technical, but is far from minor. By inserting reference to proposed new section 9AA, it lays the groundwork for a standalone statutory right for pupils to withdraw from religious observance. That is not a small drafting change, it is a structural shift that separates the pupil's position from a long-established parental right. Amendment 17 then gives the new structure real force. It creates a direct enforceable right for any pupil to request withdrawal and obliges schools to give effect to that request. While it mentions parental direction, the ultimate and final decision rests with the pupil, with capacity presumed unless shown otherwise. This is more than consultation. It is a transfer of authority from the parent, who carries legal responsibility for the child, to the pupil and, by extension, to the school to enforce it. No one here disputes that children's views matter. We all want children to be heard, particularly as they grow and mature. But there is a difference between listening to a child and giving them a parallel independent right to override the decisions of the people who are legally responsible for their welfare and upbringing. Responsibility without authority is not a balance, it's a contradiction. Amendment 7 compounds the problem by giving ministers the power to introduce an independent pupil right of withdrawal through regulations. That would allow a fundamental change to the parent-child relationship to be made by secondary legislation rather than proper scrutiny by this Parliament. It would place schools in a difficult position of mediating family disputes where the parent's lawful decision could be overridden by a head teacher. I believe at stake here is more than a procedural detail. It is a principle that parents who carry responsibility for their children must also retain the authority to make decisions about their moral and religious formation. These amendments erode that principle and risk creating unnecessary conflict within families. For that reason, I urge...
Is Mr Balfour taking an intervention?
I am, sorry.
Yes, Ross Greer.
Thank you. I'm grateful to Mr Balfour for taking an intervention. I do think that this is an entirely legitimate debate in the balance of rights between parents and children. Obviously, I'll come to a different conclusion from the member. What I'm confused about is that he, like I did, and every other member of the previous Parliament, voted for the UNCRC bill. These amendments, the specifics that we're debating in this bill, are simply putting into practice the principles that we all already voted for. I wonder if Mr Balfour could explain to me why it was he voted for putting the UNCRC into Scots law, but now disagrees with the logical conclusion of that, actually putting it into practice.
Jeremy Balfour.
Can I thank the member for his intervention? I think what we did, we implemented a piece of law, but we also recognise, as we implemented that law, that there is a balance between children's rights and parental rights. I think these amendments go beyond the scope and go too far. And for that reason, I don't think there's a contradiction. I think you can absolutely support what we passed previously, but recognise that these amendments specifically erode too far parental responsibility. And for that reason, I would ask the Chamber to reject them. Thank you.
Thank you, Mr Balfour. I call Paul O'Kane.
Thank you very much, Presiding Officer. And similarly to at stage 2, I wish to just pass comment on these amendments and for perhaps the benefit of the rest of the Parliament who weren't in stage 2 proceedings, perhaps just reiterate some of the arguments I brought up at that point. I think the arguments for this from a child's right perspective, I understand why they're being made and I understand why they're being advanced, but they do perhaps only look at one particular section, an interpretation in terms of the Convention on the Rights of the Child and what it actually says in terms of Article 14 and what it says in terms of its broader totality. Because Section 2 of Article 14 on the rights of the child to freedom of belief and religion state that state parties shall respect the rights and duties of the parents and, when applicable, legal guardians to provide direction to the child in exercise of his or her right in a manner consistent with the evolving capabilities of the child. So the UN Convention itself maintains a place for parents to direct their children, and that is language which may sound harsh, perhaps, but it's a language that would be reflected in legislation in Scotland in terms of the Children in Scotland Act and the rights that parents have. So amendments which seek to introduce an independent opt-out on the part of the child, whether on the face of the bill or by secondary legislation, don't appear to contain any reference to the rights of parents to be involved in that process. Yes, I'll take Maggie Chapman.
Maggie Chapman.
I'm grateful to Paul O'Kane for taking my intervention. Does he accept, though, that whilst we're talking about balancing rights, nothing in any of these amendments restricts parents seeking to educate or to take their children to religious observance practices that do not happen in their educational setting? This is about what happens in schools, and surely the child in that environment should have the right to exercise their convention, the rights that they are given under UNCRC.
Paul O'Kane.
The point that I'm making, and the point I think I made to Maggie Chapman in stage 2 proceedings, is that if we are going to have a wider discussion about an independent opt-out, there has to be due regard given to those parental rights that are set out, both in terms of the article that I referred to, Article 14, in terms of what the UNCRC actually says, and in terms of the law in Scotland as it stands, in terms of parental rights to direct their children. And my concern would be if we're trying to do this at this point in the bill, and I said this at stage 2, it does strike me as being a rather rushed process in order... if Ms Slater allows me to finish this point, it does feel like a rather rushed process. It doesn't give that due regard, as I say, to the role of parents, either on the face of the bill or in guidance as proposed. And I'll take Ms Slater.
Lawrence Slater.
I have a question for the member, which is around the rights of a parent who is an atheist, for example, to direct their child's education. And you're arguing that the child should have a right to opt into that religious education, but not to opt out. What about the rights of atheist parents? Do they not have the same rights as parents of faith?
Always the chair, Paul O'Kane.
I'm a wee bit confused by Ms Slater's intervention, because parents would have the right to opt their children out if they were atheists and they chose to remove their children from religious education. So, of course, the problem being if an atheist were to send their child to a Catholic school under the proposals which came via amendment from the Scottish Greens, they would not be able to opt their children out of religious education, which would include religious observance. So I go back to that debate we just had. So I'm just simply making the point that if we're going to have a broader discussion about children's rights to opt out, I do think you have to give due regard to parents. And I don't think that has happened so far in this bill, and I don't think it is happening in these amendments. I've said already that we have to give due regard to the long-established position in Scotland in terms of Scots law and the right to direct children as recognised in the Children Scotland Act 1995 and in the Scottish Schools Parental Involvement Act of 2006, and that's been reaffirmed in other acts throughout the course of the 25 years of the Scottish Parliament and of devolution. So I do think these amendments would bring the bill into conflict with fundamental principles that have been established, and I think there is, as I say, a much wider conversation if we are going to seek to change those fundamental principles and give due regard to the UNCRC in its totality. I think also, I'm concerned, we've had a previous debate, obviously, on maturity and capacity. What I think that did also was start to unpick a lot of the very complicated debate. I mean, the debate is now running over time because actually I'm not sure people appreciated quite fully how complicated this can be and actually how much detail needs to be gone through in order to take on board the variety of views which exist in this space. And there has not been, I don't believe, scoping work done on how widely any new rights on the part of children would be used and how that might affect schools in terms of practice and in terms of delivery of education. I'll take Graeme Simpson.
Graeme Simpson.
Thank the member for taking the intervention. What would Paul O'Kane do, what would he suggest we do where a pupil is an atheist and is adamantly an atheist, but their parents aren't? What would he do in that situation?
Paul O'Kane.
Well, I thank Mr Simpson for his intervention, and of course he is pointing to, I presume, a desire for that young person to be able to unilaterally opt out of religious observance or religious education. I think the point was made at stage 2 that there is perhaps a broader discussion to be had about how do you ensure that both parents and their children can be included in a discussion around opting out of processes. And what I'll take Mr Kerr, if you'll just allow me to respond to Mr Simpson's point. Because of the fundamental complexity, I think, of how law interacts and how the UNCRC might interact, there has to be a space in which parents and children are able to be brought together, and that the school, crucially, is involved in that conversation as well. But I think that is a more detailed process than what we are being offered here today. Mr Kerr.
Stephen Kerr.
Answer to the intervention from Graeme Simpson is you would tell the child to speak to their parents. I mean, that is ultimately what this comes down to. We've got to be pragmatic about this, and respecting family life means you encourage children and parents to speak to each other.
Okay.
Thank you. I mean, I'm always happy to be a conduit for members to have a wider debate, but I think Mr Kerr puts his view on the record. But, you know, he makes a fair point. I think it's what I was trying to allude to Mr Simpson. We do have to have a system where the views of children and young people are taken into account under UNCRC, but with that due regard to parents and, of course, to the school as well. Additionally, I think we have to be cognizant of unintended consequences of how things might work in practice, particularly in the denominational sector, where I've already spoken about there not being clearer distinctions in observance and education, and children choosing to opt out of religious observance and education without any discussion or parental involvement might be in effect opting out of the whole school setting, which was chosen by their parents for the very reason that it is a faith school. And it might be impossible, in fact, for those young people to be able to remain in that school without that wider conversation and discussion to which I speak. And lastly, and I think going to the heart of the issue of the bill as a whole, all of us would accept that this is a fundamental change in many ways, and it would be wrong, I think, for that independent opt-out to be introduced by ministerial power without further significant and lengthy debate by this Parliament. I think that we're still considering this issue at stage 3 without any debate on pre-legislation or the myriad of challenges that might both practically and ethically come up, shows that it is perhaps wrong for this bill to be taken forward in this way with these amendments with so little time for debate and discussion. So I think at that point, Presiding Officer, I will leave my remarks there. Thank you.
Thank you, Mr O'Kane. I call Stephen Kerr.
Thank you, Presiding Officer. Nothing that those of us who are speaking against Maggie Chapman's amendments, none of us that are speaking against them in any way would contradict the statement she led her remarks with, that children have a right to be listened to and taken seriously. I don't think that's a contentious point of view. I don't think anyone would disagree with that. I mean, a number of things that Maggie Chapman said I find strange. I mean, I look forward to hearing from the Cabinet Secretary in due course, because Maggie Chapman seemed to suggest that the Cabinet Secretary was minded to accept 7A. Don't see how you can accept 7A without 7, and that would be no. I can get to the the message on that. But I think Paul O'Kane is right when he's focused on the rights of parents, and that's been my concern with this from the very beginning. In one way or another, I think we need to respect the rights of parents, and this is what this bill fundamentally, I feel, fails to do. Because this group of amendments is asking who ultimately decides in matters of conscience within a child's education. And Amendments 16 and 17 would create that freestanding statutory right for a pupil to withdraw from religious observance independent of their parents, and 7 and 7A would empower ministers to introduce and expand that right by regulation. So let's begin with what is not in dispute. As I say again, children must be heard, should be heard. The principle of evolving capacities is well understood. No one in this chamber believes that young people are incapable of forming serious views, but that is not the issue before us. The issue is responsibility. And the UN Convention recognises not only the voice of the child, but the responsibilities, rights and duties of parents to provide direction and guidance. Section 9 of the 1980 Act has long reflected that principle. It locates the right of withdrawal in the parent. It recognises that parents are not advisory participants in their child's upbringing. They are responsible for their child's upbringing. This bill has already altered that balance. It's requiring schools to involve pupils formally in the process and in certain circumstances refuse a parental request if the pupil objects. That is a significant shift. And Amendments 16 and 17 go even further. They do not refine the process, they change who decides. And creating that independent statutory right for the child means the school becomes the mediator and potentially the arbiter between parent and child on matters of conscience. That's why I intervened on Paul O'Kane in response to Graham Simpson's intervention, because ultimately we've got to be very careful of the sacrosanct nature of family life. This is not a minor adjustment that we're talking about here this afternoon, hence the intricate nature of the debate, as Paul O'Kane says. This is a structural rebalancing of authority between the family and the state, and we should not make that shift lightly. And there's also the question of maturity, which we've addressed previously. The amendment assumes capacity unless contrary is shown. Yet in Scots law, 16, as I've already said in previous group, is the recognised threshold of legal capacity. It's the age at which young people acquire significant rights and responsibilities. These amendments are not anchored to that established framework. Instead, they create a broad and uncertain standard that schools will be required to interpret case by case. That's not clarity. I'm afraid that creates ambiguity. I give way to Martin Whitfield.
Grateful to Stephen Kerr for taking the intervention, and indeed following the acceptance of his Amendment 5, where individuals are to act impartially, it's going to make a very difficult situation even more difficult if this amendment passes.
Stephen Kerr.
I'm grateful for that intervention because he highlights something that I hadn't even thought of. Exactly right. Accepting Amendment 5 does change the complexity of the amendments we're now discussing. And Amendments 7 and 7A raise a further constitutional concern. They would permit ministers by regulation to introduce or extend this independent right, and that is a major policy choice. It goes to the heart of the relationship between parent, pupil and the state, and it should not be delegated to secondary legislation. I think this was already said. I mean, if we're going to consider this particular change, it needs to be a matter of primary legislation. Parliament needs to be fully involved in the recalibration of that balance, with full scrutiny and full responsibility resting on this chamber. So let's be clear, respecting children's voices does not require diminishing parental responsibility. Balance does not mean displacement. Reform does not require the state to insert itself more deeply in the internal life of the family, unless there's a compelling reason to do so. And goodness knows, this Parliament's already been through all of these issues in other legislation. So I don't know that we can rehearse this, but I mean, it's already a matter of fact in law that family life is something that should be a primary consideration of us as lawmakers when we create new legislation. So for that point and for all of the other points that were made by myself and other speakers in this debate, while I acknowledge the intention behind these amendments, I cannot support 16, 17, 7 and 7A.
Thank you, Mr Kerr. I now call the Cabinet Secretary.
Presiding Officer, as we've heard, introducing a new independent right for pupils to withdraw from religious observance would be a significant change, both in terms of legislation and the purpose of the bill, and operationally for schools. Now, this was discussed during the Stage 1 debate, and the Equalities Committee made very clear that a majority of committee members considered it more appropriate to proceed with the approach as set out in the bill, giving pupils the right to object to parental withdrawal while maintaining the balance between children's evolving capacities and parental rights and responsibilities. Now, the bill does just that. It ensures that pupils' views are properly taken into account while preserving the rights and responsibilities of parents. However, where I am able to support Ms Chapman is on her Amendments 7 and 9, which would provide Scottish ministers with an affirmative regulation-making power to create a right for pupils to request withdrawal from religious observance. I have also listened carefully to the strong views expressed by many in the Chamber on a pupil right to withdraw, as well as by stakeholders such as the Children and Young People's Commissioner, UNICEF UK, Together and Humanist Society Scotland. I have also reflected on the views of the Equalities Committee more broadly. Amendments 7 and 9 are consistent with the majority committee view at Stage 1 that ministers, and I quote, give further consideration to providing children with an independent right to withdraw in future legislation. Amendments 7 and 9 require appropriate consultation in advance of laying the regulations, which would be subject to the affirmative procedure. Yes, I will do.
Stephen Kerr.
He has just used a turn of phrase, which I think it's important that I have heard and others will have heard correctly. Does she interpret 7 to mean as a basis for future primary legislation, or as the basis for secondary legislation that would create this independent right of withdrawal?
Cabinet Secretary.
I will come on to that exact point now. So, on that basis, Presiding Officer, I can agree to these amendments, which, as we have heard, would grant ministers the power to make regulations to create a right for pupils to request to withdraw from religious observance. That means that future governments would have the power to use this bill to introduce such changes and could also do so through future primary legislation. Crucially, that will be, though, for a new government and a parliament to consider, and in light of the committee's advice, one that should be considered very seriously by any incoming government. I would.
Stephen Kerr.
I will recognise this is rather a major policy direction that she's taking us in relation to 7. Because that's not what 7 says. I understand that she's putting an interpretation on the wording in 7 to say that it could lead to primary legislation, but in actual fact it says, the actual wording says, Scottish ministers may by regulations provide for pupils to have the right to request withdrawal. Is she saying, what is her interpretation of those words? Because that says to me that ministers can, by secondary legislation, introduce this independent right, as opposed to bring forward legislation after consideration.
Cabinet Secretary.
Presiding Officer, that I'm not able to agree to Amendment 7A, which relates to the timescales associated to the implementation, for example, of Amendment 7. So I'm not able to agree to Amendment 7A, which would require ministers to lay those regulations as soon as reasonably practicable. This is, as I have mentioned, for a new government to decide after appropriate consultation. But the bill represents important progress, to my mind, in strengthening children's rights. This will continue to be an incremental journey more broadly. I'm happy to give way, Presiding Officer.
Because I'm still not clear about whether this is an amendment that leads to secondary legislation or primary legislation, because I think it was Paul O'Kane that said, or maybe it was all of us, that if we're going to go down this route, it needs to be considered by Parliament through the full force of its scrutiny, not as an amendment at stage 3 in this bill.
Cabinet Secretary.
Presiding Officer, that is exactly why, as I've set out, the Government is not supportive of 7A in that regard, because we need wider consultation on the proposed changes that 7 could bind future governments to. And that's exactly why, of course, in Amendment 23, it contains a requirement for ministers to review the implementation of Part 1 within 3 years. Now, that review will include explicit consideration of whether any future action should be taken in relation to enabling pupils to withdraw from religious observance. I give way to Mr Simpson.
Graeme Simpson.
I actually agree with what Stephen Kerr is asking here, and I think it's clear from Amendment 7, I hope the Cabinet Secretary will agree with me, and indeed Amendment 9, that this is about introducing regulations, not primary legislation, because that's what both amendments say. So if Stephen Kerr is uncomfortable with that, then he should be voting against it, because it doesn't introduce the power to bring in primary legislation. It's regulations. Now, some of us may be okay with that. If Stephen Kerr's not, then he should clearly be voting against it.
Cabinet Secretary.
I thank Mr Simpson for providing Mr Kerr with some views in relation to his view on this amendment. Of course, my own view is that primary legislation would be more appropriate in that regard. However, Amendment 7, the member is correct to say, does give future governments flexibility in relation to the regulation-making power should future governments deem that appropriate. Now, I think it is worthwhile putting on the record, Presiding Officer, that any changes that are made by the bill, potentially, if it passes today, will have been in place for 2 to 3 years, and we will have had much more evidence on completion of the review that I mentioned and the data surrounding withdrawals from religious observance. And this was a key feature of some of the debates I had with the committee at stage 2 in relation to the lack of data that we currently have in relation to withdrawals. So it's imperative we have that data to inform potential future legislative changes. So future ministers, as I have alluded to, would be able to make a much more informed decision. That would be an appropriate time for future changes arising from that review to be brought forward through a subsequent bill, for example, as part of any wider reforms that may come forward in relation to the 1980 Education Act, ensuring that we have that full debate and parliamentary oversight, which would be, to Mr Kerr's point, my clear preference. I do stress again, yes, I will do.
Polly McNeill.
I'm trying to follow this debate, and I may not have understood it, but if it's the government's position that it should be, instead of Amendment 7, that ideally it should be primary legislation, and I agree with that, because I think at this late stage it is wrong to bind a future government, but if the government's clear position is it should be primary, I don't understand why you would accept Amendment 7, because Amendment 7 does the opposite. What Amendment 7 does is it says Scottish ministers may by regulation provide for pupils to have a right to request withdrawal, but it does say consultation. But that is no different from any other secondary piece of legislation that we do in this Parliament. We do consult, and then I think it's a bit of a contradiction actually in what the government are saying. Surely you should stick to your guns. If you think that it should be primary legislation, then you should not vote for this amendment, because what this amendment does is the opposite. It gives secondary legislation and it binds a future government. So I don't really understand what the government's argument is, or you're just trying to put an olive branch out or something, because that's the only way it would make any sense to me. Thank you.
Always to the Chair, Cabinet Secretary.
Well, I think, Presiding Officer, any regulations would of course be subject to the affirmative procedure, and I've set out my position in relation to my preference on primary legislation. But it is also worthwhile reflecting the views of the Equalities Committee on this matter, who said at stage 1 that ministers should, and I quote, give further consideration to providing children with an independent right to withdrawal in future legislation. The Government has listened and responded to that matter, but I have also mentioned the work already underway in relation to the proposed wider review that would provide the evidence base potentially for future legislation in that space. And I don't agree with the suggestion that this binds future governments in that regard, because of course the review will allow ministers to consider in future governments whether or not legislation or regulations are more appropriate, and this does not shut down that avenue. I do stress again, I'd like to make some progress, Presiding Officer. I'm conscious of time. Any regulations for a pupil right to withdraw from religious observance would require significant consultation and engagement, as we have heard. And in using this power, it would be important for any government to ensure it meets the balance of strengthening children's rights, which is what this bill is about, and upholding parental rights. And I would encourage Parliament to agree to Amendments 7 and 9 and reject all other amendments in this group.
Thank you, Cabinet Secretary. I would take this opportunity to advise the members that they will note that we have in fact passed the agreed time limit for the debate on this group to finish. I exercise my power under Rule 9.8.4a brackets small c close brackets to allow debate on this group to continue beyond the limit in order to avoid the debate being unreasonably curtailed. And with that, I call Maggie Chapman to wind up and to press or withdraw Amendment 16. Ms Chapman.
Thank you, Presiding Officer. Scottish Greens are very clear. We believe that children and young people have rights. We also believe that having rights without the power to exercise them is meaningless. So we believe children and young people should have the power to exercise their rights. And so, logically, we believe that there should be an independent statutory right for children and young people to decide whether or not to participate in religious observance. As we've heard, the bill currently gives young people the right to object when a parent seeks to withdraw them. For the example that my colleague Lorna Slater mentioned, an atheist parent could withdraw a child, but the child could overwrite that parental wish and opt back in. The bill does not give those young people a reciprocal independent right to withdraw themselves in the first place. In doing so, it affords stronger protection to children who wish to participate in religious observance than to those who do not. This embeds discrimination into law, creating an imbalance in the protection of children's Article 14 UNCRC rights, that the freedom of thought, conscience and religion. Children of faith can opt into RO, but children of no faith cannot opt out. That is not right. My Amendment 17 introduces a right to request withdrawal from RO, strengthening alignment with Articles 12 and 14 of UNCRC, as well as repeated recommendations from the UN Committee on the Rights of the Child, and also with Scotland's commitment to child-centred decision-making. My amendment incorporates a presumption of capacity and a clear process for schools, ensuring proportionality and legal clarity. Amendments 7, 7A and 9 are weaker, giving ministers the power to introduce regulations by giving pupils a right to request withdrawal from RO. But this is weaker because it postpones meaningful change to a future point and leaves the right dependent on subsequent regulations being brought forward. My preferred Amendment 17 places that right directly into primary legislation right now, providing clarity and certainty now, rather than at some unspecified date in the future. Amendment 7A, though, would require Scottish governments to lay draft statutory instruments containing the first regulations as soon as possible after the relevant provision enters into force. And Amendment 9 would specify these regulations would be subject to the affirmative procedure. But I come back to that fundamental point. If we pass this bill this evening with no independent right for the young person to withdraw themselves from RO, we are embedding discrimination in law. That might be where we get to. I hope we don't, and I would urge people to support my amendments in this group. And with that, Presiding Officer, I press 16. Thank you.
Thank you. The question is that Amendment 16 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division, and members should cast their votes now. And the vote is now closed. The result of the vote on Amendment 16 in the name of Maggie Chapman is yes 12, no 106. There were no abstentions. The amendment is therefore not agreed. I call Amendment 17 in the name of Maggie Chapman. Already debated with Amendment 16. Maggie Chapman to move or not move. The question is Amendment 17 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote's closed. The result of the vote on Amendment 17 in the name of Maggie Chapman is yes 13, no 103. There were no abstentions. The amendment is therefore not agreed. Call Amendment 18 in the name of Maggie Chapman. Already debated with Amendment 16. Maggie Chapman to move or not move?
Not moved.
That is not moved. I call Amendment 19 in the name of Eleanor Whittam. Already debated with Amendment 1. I would remind members that if Amendment 19 is agreed to, I cannot call Amendment 20 due to a preemption. Eleanor Whittam to move or not move?
Move, Presiding Officer.
The question is that Amendment 19 be agreed to. Are we all agreed? That is not agreed. There will be a division and members should cast their votes now. And the vote is now closed. The result of the vote on Amendment 19 in the name of Eleanor Whittam is yes 89, no 29. There were no abstentions. The amendment is therefore agreed. Call Amendment 7 in the name of Maggie Chapman. Already debated with Amendment 16. Maggie Chapman to move or not move?
Moved.
Thank you. I call Amendment 7A in the name of Maggie Chapman. Already debated with Amendment 16. Maggie Chapman to move or not move?
Moved.
Question is that Amendment 7A be agreed to. Are we all agreed? No. Parliament's not agreed. There will be a division in members who cast their votes now. And the vote is now closed. The result of the vote on Amendment 7A in the name of Maggie Chapman is yes 12, no 106. There were no abstentions. The amendment is therefore not agreed. I call Amendment 7 already debated. No, Maggie Chapman to press the withdrawal Amendment 7. Question is that Amendment 7 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division in members who cast their votes now. And the vote's closed. And the result of the vote on Amendment 7 in the name of Maggie Chapman is yes 70, no 47. There were no abstentions. The amendment is therefore agreed. Call Amendment 21 in the name of Elena Whittam, already debated with Amendment 6. Elena Whittam to move or not move?
Move, President.
Question is that Amendment 21 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division in members who cast their votes now. And the vote's closed. The result of the vote on Amendment 21 in the name of Elena Whittam is yes 73, no 44. There were no abstentions. The amendment is therefore agreed. It takes us to Group 4, reporting on religious observance and withdrawal from it. I call Amendment 8 in the name of Maggie Chapman. Group with Amendments 12 and 23. Maggie Chapman to move Amendment 8 and speak to amendments in the group.
Thank you, Presiding Officer. As we are creating new rights, it's important that we monitor how they are being used, so we will know whether young people are being made properly aware of their rights and supported to exercise them. Amendment 8 does this, and I'm grateful to the Cabinet Secretary for us working together to get this amendment here. Amendment 8 would require the Scottish Ministers to publish an annual report detailing the number of pupils who have been withdrawn from religious observance. This addresses widespread calls from stakeholders and the Equalities, Human Rights and Civil Justice Committee for more evidence about religious observance in schools. This amendment therefore aims to ensure that information on withdrawals from RO is collected in a way that is both proportionate and manageable, and that does not impose unnecessary or additional workload on schools. The intention is that the figures required for this report would be gathered using existing powers and processes. An annual return would allow for further understanding of the number of withdrawals from religious observance, as well as supporting the monitoring of any trends over time. While this proposed annual data gathering requirement is fairly narrow, my hope is that the Scottish Government will not limit itself to gathering this data alone, but that this data will be used as a starting point for more in-depth evidence gathering. And Amendment 12 allows us to get regular updates on the use of RO more generally. Some schools have followed Scottish Government guidance and adopted a time for reflection model of religious observance. This more inclusive approach is less focused on prayers and religious worship and more about reflecting on a moral issue without being led in a particular way of thinking. Schools tend to invite a range of speakers from different faith and non-faith backgrounds, much like our own Parliament. However, research from the Humanist Society Scotland shows that in some non-denominational schools, RO is still largely or wholly delivered in a Christian manner. Assemblies are often held in church and involve religious worship, prayers and hymns. Non-inclusive practices such as these can isolate and discriminate against pupils, parents, guardians and teachers who do not hold Christian beliefs. That's why it's important to monitor how RO is taking place in our state schools, which is covered by 2A. Where students do withdraw from RO, it is crucial that a high-quality alternative provision is put in place, so these young people are not disadvantaged. And 2C of my amendment covers this. It's actually very much in line with Stephen Kerr's earlier amendment. I hope the Chamber can support my amendments this evening so that we can ensure the rights we are creating in law are being respected in practice and that religious observance in our schools is delivered in a way that is appropriate for our multi-faith society. Eleanor Whittam's Amendment 23 is similar to my amendments in this group, and I support her amendment as well. So I'll leave it there for now, Presiding Officer. Thank you.
Thank you very much. And I'll call Eleanor Whittam to speak to Amendment 23 and other amendments in the group. Ms. Whittam.
Thank you, Presiding Officer. I move Amendment 23 in my name. Amendment 23 proposes the introduction of a single statutory review of the implementation of the changes to the withdrawal process to be published 3 years after these provisions come into force, representing a proportionate and workable approach. By allowing a reasonable period of time to pass before the review is undertaken, it ensures there is sufficient evidence and practical experience to assess whether the legislation is operating as intended. Under this amendment, the review would also consider how religious observance has been delivered during the period in question and would include an assessment of how inclusive that provision has been. This aims to respond to the concerns raised during the parliamentary process regarding the dearth of evidence about the current form and delivery of religious observance by growing the existing evidence base in this respect. And this is especially important given the FOI responses published last week by Humanist Society Scotland. Importantly, Amendment 23 requires ministers to set out what actions they intend to take in response to the review's findings or to explain clearly if no further action is proposed. And this also extends in particular to any actions to enable children to independently withdraw from religious observance. Finally, ministers must lay a copy of this report before the Scottish Parliament. I therefore encourage members to support Amendment 23.
Thank you. A brief contribution from Paul O'Kane.
Thank you, Presiding Officer. Given the concerns that were expressed at Stage 1 and Stage 2 on the lack of evidence and data on religious observance and withdrawals, it is right that we work to address that deficit. It does, however, remain odd that we're making changes to withdrawals without the data and the work hadn't been done before introduction of this bill. So it is clearly an oversight which needs to be addressed. And I do welcome the conversations I had with the Cabinet Secretary on this matter, and the work can now be undertaken to address the issue. In respect of the amendments before us, Scottish Labour will support Amendments 8 and 12. They are both balanced, reasonable and clear. However, we cannot support Amendment 23 in the name of Eleanor Whittam. I believe that most of what that amendment seeks to do is achieved by Maggie Chapman's Amendment 12, but perhaps referring back to the arguments previously made this afternoon on an independent opt-out and specific reference to that in Amendment 23 means that we would not be able to support it. Thank you.
Thank you. Call the Cabinet Secretary.
Presiding Officer, as we've heard, Maggie Chapman's Amendment 8 limits the reporting requirement to the number of withdrawals only, rather than seeking more detailed data that would be burdensome for schools to collect. And I think Mr O'Kane's correct to highlight the data deficit that we've seen in relation to this issue. Annual collection, as we know, would give a much better understanding at a national level of the number of withdrawals to be established and trends in withdrawals to be monitored over time. And for those reasons, the Government will support Amendment 8. Amendment 12, also in the name of Maggie Chapman, would require ministers to commission, publish and lay before Parliament an independent report on religious observance in public and grant-aided schools. The first report would be produced within 2 years of royal assent and thereafter every 5 years. The amendment sets out an extensive list of required content: the form and content of religious observance, how withdrawal rights are operating, the availability of alternative activities, UNCRC compliance in relation to both the content of religious observance and the withdrawal process, and any further matters the appointed independent person considers important. And while these matters are all relevant, the amendment brings several challenges. Commissioning an independent report of this nature is likely to be significantly more costly than conducting a review internally, and it is not clear that the additional expense would be justified by added benefit. A requirement for the first report within 2 years of royal assent may also prove premature, particularly as the provisions may not yet have been fully embedded before data gathering must commence. The amendment then mandates ongoing reports every 5 years in perpetuity. Given the relatively small number of pupils expected to be affected by withdrawal rights, this does appear disproportionate. Additionally, the amendment does not place any duty on operators of schools to provide the reporter with information, and this may mean that information gathering would need to go through the Scottish Government in any case, potentially compromising the perceived independence of these reports. Taken together, these issues suggest that Amendment 12 would impose a high-cost ongoing reporting structure, which may not provide commensurate benefits. For those reasons, I do not support Amendment 12. However, I do recognise the intention of this amendment in improving the evidence base, as has been discussed this afternoon. To that end, I would encourage members to instead support Amendment 23 as an alternative. Eleanor Whittam's Amendment 23 introduces a one-off statutory review of the implementation of the Bill's provisions to be published 3 years after commencement. That approach is more proportionate than that outlined in Amendment 12, and it allows for meaningful evidence to be gathered over a reasonable period, supporting ministers in assessing how the provisions are working in practice and whether further changes or guidance may be required. It also avoids the need to request significant recurring data from schools and local authorities. The review would be required to include information on how religious observance has been delivered during the period, as well as an assessment of the inclusiveness of its content and delivery. This speaks directly to concerns raised by the Humanist Society and others regarding non-inclusive practices, which Ms Chapman has alluded to this afternoon, and will help to determine whether those concerns persist following the updated guidance. The amendment also requires ministers to set out actions they intend to take in light of the review, or to give reasons if they do not propose to take action, in particular in relation to actions to enable children to withdraw from religious observance. This ensures transparency and accountability in responding to the findings. The one-off nature of the review strikes an appropriate balance, and it provides sufficient depth of information at an appropriate time, while minimising ongoing administrative burden and cost to the teaching profession. And for those reasons, I support Amendment 23. And in summary, the Government will support Amendments 8 and 23 as proportionate and practical measures. Amendment 12, though, as I have mentioned, would impose a disproportionate and ongoing reporting requirement, and I would ask that Maggie Chapman does not press accordingly.
Thank you. I call on Maggie Chapman to wind up press or withdraw Amendment 8.
Thank you, Presiding Officer. My Amendment 8, as we've heard, requires Scottish Government to report on the number of pupils who have been withdrawn from RO during the school year and as soon after the end of that school year as possible. Because this amendment is needed because of the gap, the significant evidence gap identified in earlier stages, and it will support greater transparency and accountability. One thing, though, the Cabinet Secretary indicated that it's likely that it will be very small numbers. Well, we just don't know. That's part of the question, part of the issue. We just don't know, which is why I think we need Amendment 12. We also continue to support ongoing qualitative as well as quantitative reporting, and I'd encourage the Scottish Government to report on the form and content of RO, reasons for withdrawal and other information just beyond just the number of withdrawals. My Amendment 12 is stronger than Amendment 23 because of its independent nature and the independence of the periodic reporting. I appreciate what the Cabinet Secretary says about cost and the burden of this, but I think because we just don't know the state of play at the moment, because of the very varied behaviours across Scotland, we need that information. I'll close with a note from Together, Presiding Officer, that whilst they understand these amendments could improve our understanding of RO across Scotland and help ensure consistency and in rights respecting practices, there have also been calls for making RO a thematic inspection by HMIE as a better way of achieving this. Now, I'd thought about bringing an amendment to that effect today, but didn't. But I do think we need to consider what more we can do to make sure we have the information across the board and not just the numbers. But I'll close by pressing my Amendment 8. Thank you.
Thank you. The question is that Amendment 8 be agreed to. Are we all agreed? Yes. Are we all agreed? Yes. Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. Point of order, Neil Gray.
Out on my phone, I would have voted yes.
Thank you. I'll make sure that is recorded. Point of order, Alistair Allen.
Likewise, I couldn't connect. I would have voted yes.
Thank you. I'll make sure that is recorded. Point of order, Pauline McNeill.
I would have voted yes, Presiding Officer.
Thank you, Ms McNeill. I'll make sure that is recorded. Point of order, David Torrance.
I would have voted yes, Presiding Officer.
Thank you. I'll make sure that is recorded. Point of order, Sharon Dowie.
It's the people on...
Point of order, Sharon Dowie.
I would have voted no.
Thank you. I'll make sure that is recorded. The result of the vote on Amendment 8 in the name of Maggie Chapman is yes 89, no 24. There were no abstentions. The amendment is therefore agreed. I call Amendment 9 in the name of Maggie Chapman, already debated with Amendment 16. Maggie Chapman to move or not move?
Moved.
The question is that Amendment 9 be agreed to. Are we all agreed? Yes. Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. Point of order, David Torrance.
Thank you, Presiding Officer. I would have voted yes.
Thank you. I'll make sure that is recorded. Point of order, Marie Todd.
I'd have voted yes too. Thank you.
Thank you, Ms Todd. I'll make sure that is recorded. The result of the vote on Amendment 9 in the name of Maggie Chapman is yes 91, no 24. There were no abstentions. The amendment is therefore agreed. It takes us to Group 5, making freestanding provision for pupil involvement in withdrawal requests. I call Amendment 10 in the name of Maggie Chapman in a group of its own. Maggie Chapman to move and speak to Amendment 10.
My Amendment 10 has the same aim as my other amendments, and the original bill in terms of the rights of the rights of children and young people. It ensures that young people can be heard in any decision made by their parents to withdraw them from RO. However, the key difference is that this amendment would mean the provisions are enacted as a standalone provision rather than as amendments to the 1980 legislation. Together has argued that this places the bill out with the scope of UNCRC and would mean children would have no direct route to challenge breaches or to seek remedy if their rights in relation to these new provisions are not upheld. As well as the separation of RE and RO and the independent right to withdraw, this is one of the key changes requested by Together in its letter to the committee last October. They are designed to ensure Part 1 of the bill fully aligns with UNCRC, and I welcome their support and the support of the Children and Young People's Commissioner for this amendment. I do, however, understand that there may be some technical issues with the amendment as drafted, and I'll listen to the Cabinet Secretary to hear what her comments are before I decide whether I press this amendment. Thank you.
Thank you. I call Jeremy Balfour, followed by Paul O'Kane.
Thank you, Deputy Presiding Officer. Amendment 10 fundamentally alters the long-established balance between parental responsibility and, again, the role of the state. While it's framed as giving children a voice, it actually goes much further than that. It gives the pupil an effective veto over a parental lawful decision to withdraw them from religious observance. This is not simply consultation, but it is the removal of the parent's final say in an area that sits at the heart of family life, religious and moral upbringing.
Maggie Chapman, briefly.
So, Jeremy Balfour said that this amendment would allow a child to override their parents' wishes and not be involved in RO. But the bill already does that. It allows a child to override a parent's wishes and opt back into RO. Why the discrepancy?
Jeremy Balfour.
Because I think this fundamentally undermines the parental role in regard to what we should be doing in regard to families. Because, as I want to just point out, parents ultimately carry the legal responsibility for their children's welfare and education. We wouldn't be bringing forward an amendment today to say that children could opt out of maths or English or physical education, because those subjects, as this subject, should be up to the parent to make decisions on. With the responsibility must come the authority to make the decisions, particularly in matters of belief and conscience. As I mentioned previously, this amendment places schools in the middle of potential family disputes and transfers decision-making power away from parents. This is a significant shift in the relationship between parent and child, and for that reason, I cannot support it tonight.
Thank you. And Stephen Kerr.
Paul O'Kane.
Paul O'Kane is no longer wanting to contribute. Stephen Kerr.
Should have known better than to second-guess you, Presiding Officer. I thought perhaps you'd missed out, Paul O'Kane. I must say that I concur with what Jeremy Balfour has said. This Amendment 10 replaces Section 1 of the Bill with a freestanding statutory framework governing pupil involvement in withdrawal from religious observance. And we should be clear about what that means. And I would reiterate, this is not just a technical adjustment in law. It is really a rewriting of the architecture. The stated intention is to ensure that children are heard. That's legitimate. No one in the chamber disputes that young people can and do form thoughtful views, but this is not simply about listening. This amendment creates a formalised statutory mechanism under which a parental request can be blocked if a parent objects. It requires schools not merely to consult but to intervene. It requires them to inform, to invite objection, to seek discussion, and ultimately to adjudicate. And that is a significant shift in law. Parents are not incidental participants in the upbringing of their children. They carry legal and moral responsibility for their child's welfare, moral formation and development. The Conscience Clause in Section 9 of the 1980 Act recognised that settlement clearly. It located the right of withdrawal with the parent because matters of observance engage conscience and upbringing, and this amendment recalibrates that balance. Once the school becomes the referee between a parent and a child on a question of conscience, the state is inserted more deeply into family life. And whilst in some circumstances that may be necessary, it should be avoided wherever possible and never be routine. That principle that parents carry the ultimate responsibility for their children is a fundamental right, and that must be maintained. This amendment undermines that principle. We should also consider proportionality. The bill has already removed the parental right to withdraw from religious and moral education. It has already introduced a structured process under Section 9A. Amendment 10 does not simplify that framework. It replaces it with something more elaborate and more prescriptive. At some point, incremental procedural additions become cumulatively transformational, and we are close to that point. There is also a practical reality. Schools are already under pressure. This amendment creates a detailed case-by-case decision-making structure. It will require training. It will generate uncertainty. It risks inconsistency across authorities. It increases the likelihood of dispute, not reduces it. This is not about silencing children. It is about who decides. The principle of evolving capacities must sit alongside the principle of parental responsibility. One does not erase the other. Respecting a child's voice does not require diminishing the role of the parent or formalising the school as an arbiter in every disagreement. When Parliament legislates in matters touching conscience and faith, restraint is a virtue. Clarity is essential. Proportionality is essential. Trust in families matters. Amendment 10, though well-intentioned, I'm sure, moves the balance too far. It embeds a statutory adjudication model where careful involvement would suffice. And for those reasons, I cannot support Amendment 10.
I'm going to call the Cabinet Secretary.
Presiding Officer, Group 5, as we've heard, consists of Amendment 10 in the name of Maggie Chapman, which would create this standalone provision within the bill rather than amending the 1980 Act. And I think while the intention is commendable, the amendment has very significant consequences for the structure and effect of Part 1 of the bill, because if Amendment 10 were agreed to, none of the changes currently made by the 1980 to the 1980 Act by Section 1 of the bill, including as a result of our Stage 2 amendments, would take effect, and I don't think that was Ms Chapman's intent. Furthermore, though, Amendment 10 deals only with withdrawal from religious observance. It doesn't make provision for pupil involvement in decisions about withdrawal from religious and moral education. The current law on withdrawal from religious and moral education would therefore remain unchanged, and pupils would have no right to be involved in those decisions. And in addition, any Stage 3 amendments to Section 1 agreed before Amendment 10 would fall away entirely. Presiding Officer, the amendment also raises several other concerns. By creating a standalone provision, Amendment 10 removes the withdrawal process from the wider legislative framework of the 1980 Act. Key terms such as pupil, parent and school are not defined in the amendment, and the 1980 Act definitions would not apply automatically. Without those definitions, ordinary meanings would apply, which could exclude legal guardians, carers and others with parental rights and responsibilities. Again, I do not think that was Ms Chapman's intention, but this would sit uneasily with the rest of the statutory framework and create uncertainty for schools and families. The Government's view remains that the correct and pragmatic approach is to amend the 1980 Act directly. It is complex and it's a long-standing piece of legislation, as we've heard this afternoon, and all the other provisions concerning religious observance and RME are in that Act. So the bill makes focused amendments to address specific concerns rather than attempting to replicate or replace entire sections of the existing statute. Reenacting only parts of that framework, as I think we actually debated during stage 2, within a new act would risk producing fragmented and incoherent legislation. The consequences of Amendment 10 demonstrate why I resisted those proposals, as I have alluded to at stage 2. So although well-intentioned, here standalone provision does risk creating legal uncertainty, and I am mindful of time, Presiding Officer. So for those reasons, I cannot support Amendment 10, and I would ask Maggie Chapman and other members not to press.
Thank you, Maggie Chapman. To why not press the withdrawal Amendment 10?
Thank you, Presiding Officer. Just a couple of points. It's utterly nonsensical to say that a child must be listened to when they want to opt into RO, but that a child must not be listened to when they want to opt out of RO. That makes no sense. And to address another of Jeremy Balfour's points, we separated RO and RE at stage 2. RO is not a matter of education, but a matter of faith. So I think that point really needs to be made. There's nothing in this amendment that would lead to the possibility of withdrawal from maths or any other education subject. Having said that, I'd like to reiterate my disappointment that the way this bill has been drafted makes it out of scope of UNCRC, but I do accept the points that the Cabinet Secretary has made, and with that I will not press Amendment 10. Can I clarify that you're withdrawing?
So the member is looking to withdraw Amendment 10. Does any member object? No members object. So Amendment 10 is withdrawn. I call Amendment 11 in the name of Maggie Chapman. Already debated with Amendment 6. Maggie Chapman, to move or not move?
Moved.
Question is Amendment 11 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members who cast their votes now. And the vote is closed. Point of order, Jeremy Balfour.
Apologies, it's come through.
The result of the vote on Amendment 11 in the name of Maggie Chapman is yes 12, no 104. There were no abstentions. The amendment is therefore not agreed. Call Amendment 22 in the name of Maggie Chapman. Already debated with Amendment 6. Maggie Chapman, to move or not move?
Moved.
The question is that no. I call Amendment 22A in the name of Maggie Chapman. Already debated with Amendment 6. Maggie Chapman, to move or not move?
Also moved.
The question is that Amendment 22A be agreed to. Are we all agreed? No. Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. The result of the vote on Amendment number 22A in the name of Maggie Chapman is yes 7, no 109. There were no abstentions. The amendment is therefore not agreed. Okay, Maggie Chapman to press or withdraw Amendment 22.
Press.
The question is that Amendment 22 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division of members who cast their votes now. And the vote is now closed. The result of the vote on Amendment 22 in the name of Maggie Chapman is yes 11, no 87. There were 19 abstentions. The amendment is therefore not agreed. I call Amendment 12 in the name of Maggie Chapman. Already debated with Amendment 8. Maggie Chapman to move or not move?
Moved.
The question is that Amendment 12 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division of members who cast their votes now. Votes closed. The result of the vote on Amendment 12 in the name of Maggie Chapman is yes 26, no 91. There were no abstentions. The amendment is therefore not agreed. I call Amendment 23 in the name of Eleanor Whittam. Already debated with Amendment 8. Eleanor Whittam to move or not move? Question is that Amendment 23 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division of members who cast their votes now. And the vote's closed. Point of order, Craig Hoy.
Apologies, Deputy Presiding Officer. My app froze. I would have voted no.
Thank you, Mr Hoy. I'll make sure that's recorded. The result of the vote on Amendment 23 in the name of Eleanor Whittam is yes 73, no 45. There were no abstentions. The amendment is therefore not agreed. I call Amendment 24. Apologies. Yes 73, no 45. No abstentions. The amendment is agreed. Call Amendment 24 in the name of Paul O'Kane. Already debated with Amendment 6. Paul O'Kane to move or not move?
Moved.
The question is that Amendment 24 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division of members who cast their votes now. And the vote is now closed. The result of the vote on Amendment 24 in the name of Paul O'Kane is yes 50, no 68. There were no abstentions. The amendment is therefore not agreed. It takes us to Group 6, scrutiny of use of exemptions. Call Amendment 25 in the name of the Cabinet Secretary. Group with Amendments 13, 13A, 14 and 15. Cabinet Secretary to move Amendment 25 and speak to other amendments in the group.
Presiding Officer, I move Amendment 25 and I will speak to it and all of the other amendments in the group. This group covers quite a technical and legally complex number of issues, so I hope members will bear with me. I very much recognise the calls for greater transparency around the use of the Section 6B exemption introduced by the bill. During Stage 2 proceedings, I committed to bringing forward a government amendment to introduce a reporting requirement on Scottish ministers. That commitment was in direct response to the amendments from Maggie Chapman and from Stephen Kerr. I also note it has been a key ask from children's rights stakeholders. Amendment 25 delivers on that commitment. It requires Scottish ministers to report on the use of the Section 6B exemption annually to the Parliament through the existing framework of the Children's Rights Scheme. Specifically, ministers must report on notifications received under the court-based processes introduced at Stage 2, by which the Lord Advocate, the Children's Commissioner and the Scottish Human Rights Commission are notified when Section 6B exemption is raised in legal proceedings. Subject to Amendment 13 passing, which I will speak to shortly, ministers would also report on notifications received from certain public authorities named in the UNCRC Act. Importantly, this amendment also requires ministers to report on any actions they intend to take in response, supporting both transparency and accountability. Amendment 15, in the name of Maggie Chapman, requires ministers to undertake an audit of legislation and report on the findings. And while I welcome the intent, I believe that my Amendment 25 provides for a more proportionate and coherent approach. This is because Amendment 25 ties directly into the notification and intimation framework, which this bill seeks to add to the UNCRC Act, and the reporting obligations for the Children's Rights Scheme. In any event, Amendment 15 would operate in a similar way to my Amendment 25, but I believe that Amendment 25 is clearer, more proportionate and better integrated with our existing framework, and I would ask, therefore, Maggie Chapman not to move Amendment 15 and to support Amendment 25 instead. Turning to Amendments 13 and 13A, I welcome the Equalities Committee was able to support the Stage 2 amendment introduced by the Government, which created a duty to notify when Section 6B exemption is raised in legal proceedings. However, I have listened to the concerns raised by MSPs and stakeholders that this duty may apply too late in the process because the issue will have already reached court. In response, I committed to cross-party engagement on this issue, and I am grateful for the constructive conversations I have had with members from across the Chamber and for the constructive conversations that stakeholders have had with officials. As part of that engagement, the Government worked with Maggie Chapman to develop Amendment 13. This would place a duty on listed public authorities in the UNCRC Act to notify the Government, the Children's Commissioner and the Scottish Human Rights Commission where they are of the view that they cannot read and give effect to relevant legislation in a way that is compatible with the UNCRC requirements, and that exemption in Section 6B therefore applies to the way that they have acted or proposed to act. In effect, this will ensure that concerns are flagged to the Government at an earlier point. By applying this duty only to listed authorities under Section 19 of the Act, it ensures that the duty is placed on those whose services most directly affect children and young people, and those who have the appropriate expertise to support them to assess whether that notification is required. At Stage 2, I said that any duty of this kind must be clear, proportionate and workable. And by linking the duty to public authorities' existing obligation to read and give effect to the legislation in a way that is compatible with the UNCRC requirements meets those tests. The Government has engaged directly with listed authorities on the proposal. Several welcomed the link to existing duties under the Act, felt it was proportionate and that it addressed their concerns relating to previous approaches at Stage 2. And I have also continued our positive engagement with children's rights stakeholders who are broadly supportive of this approach. Nonetheless, I note that Maggie Chapman has also lodged Amendment 13A, which would slightly modify the trigger for notification. Rather than referring to how a listed authority has acted or proposes to act, it refers to the exercise or potential exercise of a relevant function. The original wording was chosen because the Section 6B exemption centres on a public authority's actions, as does the underlying duty to act in accordance with the UNCRC requirements in Section 6 of the 2024 Act. In the Government's view, Amendment 13 is slightly clearer and more tightly aligned with the underlying legal test. That said, I do not believe Amendment 13A would significantly alter how the duty operates in practice, and on that basis, and in the interest of consensus, if Maggie Chapman chooses to move Amendment 13A, then we will support it. Finally, Presiding Officer, I turn to Amendment 14. I understand the intention behind this proposal is to give the Children's Commissioner and the Scottish Human Rights Commission an additional power to bring proceedings in order to determine the compatibility of legislation with the UNCRC requirements in cases where the 6B exemption may apply. But let me begin by affirming that we are committed to a system where legislation can be challenged in the courts. The UNCRC Act already gives the Commissioner and the Human Rights Commission the powers to do so. The Government, therefore, does not believe this amendment is necessary or appropriate. This is a key strength of the Act. It provides a clear and an effective route to test legislation in the courts where concerns arise. The UNCRC Act was also deliberately designed so that the Lord Advocate would be notified of any proceedings to challenge legislation. That is their proper constitutional role as guardian of the statute book. This amendment would therefore duplicate that route that already exists under the Act and give powers to the Commissioners, which should rest with the Lord Advocate. In addition, any significant new statutory power for Commissioners of the kind that Amendment 14 is seeking requires careful scrutiny. Stage 3 of the bill is therefore not the appropriate place to introduce it. Neither the Government nor the Parliament has had sufficient time to fully consider any financial implications and potential unintended consequences, particularly the constitutional implications of a new power. And as far as I am aware, there has not been consultation with the Court Service itself on this new power. I am also mindful of the broader context, Presiding Officer, including the findings of the Finance and Public Administrations Committee's recent report on Scotland's Commissioner landscape and the Government's response to it. There is a clear expectation that any expansion of parliamentary bodies' powers should be discussed early with the Scottish Parliamentary Corporate Body. As this amendment has only been lodged at stage 3, we have not had the opportunity to do so. I must also note this proposal was not explored as part of the Equality Committee's scrutiny of the bill. By contrast, the Government has taken action to introduce two key safeguards: the new notification duty on listed public authorities and the new reporting requirements on Scottish ministers. For all these reasons, I cannot support Amendment 14, and I would encourage Maggie Chapman not to press. If she does, I would ask members to resist Amendments 14 and 15, and I would urge members to support Amendment 25 in my name, along with 13 and 13A from Maggie Chapman.
Thank you. Members will note that we have passed the agreed time limit for the debate on this group to finish. I exercised my power under Rule 9.8.4ac to allow the debate on this group to continue beyond the limit in order to avoid the debate being unreasonably curtailed. I call Maggie Chapman to speak to Amendment 13 and other amendments in the group.
Thank you, Presiding Officer. During the committee's scrutiny of this bill, we consistently heard that a key safeguard to the exemption in Part B in Section 6B would be a statutory duty to notify the Scottish Government, the Children's Commissioner and the Scottish Human Rights Commission when the exemption may be relied upon. I supported the Government's Stage 2 amendment introducing a notification duty that applies when the exemption is raised in legal proceedings. However, I remained concerned that this only provides transparency at a very late stage when proceedings are already underway. That's why I lodged my own amendment at Stage 2 to introduce an alternative notification duty. While that wasn't agreed to, I welcome the Cabinet Secretary's commitment to work with me ahead of Stage 3 to develop a proportionate and workable alternative, and Amendment 13 reflects that joint work. I'm grateful to the Cabinet Secretary for the time that she's put into this amendment. Amendment 13 introduces a duty on public authorities listed under Section 19 of the UNCRC Act to notify the Scottish Government, the Children's Commissioner and the Scottish Human Rights Commission when they are of the view that they cannot read and give effect to relevant legislation in a way that is compatible with UNCRC requirements, and therefore take the view that the exemption may apply. This duty means that where a listed authority identifies an issue with the legislation while fulfilling its obligations under the Act, it must notify those bodies. That creates a mechanism to identify and scrutinise potential issues at an earlier stage. If we don't pass Amendment 13, then, as many instances will not reach court, will not have those legal proceedings, we will simply be living in ignorance as to how often the rights of children and young people we have incorporated into law are not being fully upheld. I understand that this revised approach has been supported in engagement with children's rights stakeholders and listed public authorities, and it directly addresses one of the key calls made during the committee's evidence taking. Amendment 13A is maybe a little bit cheeky, but it amends 13 to widen the scope of the notification duty. It would ensure that public authorities are obliged to notify the Government, the Commissioner and the Commission, not just when they are proposing to act, but when in contemplation of such an act. For example, this might be when engaged in service planning or other high-level discussions in which such issues might be expected to arise. This amendment simply ensures that public authorities will provide the Scottish Government with notification of potential incompatibilities at the appropriate point, and thereby trigger the Government's duty to assess and report to the Parliament any action it has taken in response. My Amendment 14 is necessary, I believe, in order to make Part 2 operate effectively to deliver the policy intention. It is supported by the Children and Young People's Commissioner, SHRC, Together Scotland, UNICEF, Clan Child Law and Social Work Scotland. It provides the Children's Commissioner and the Scottish Human Rights Commission with a means of responding to a notification from a public authority about potentially incompatible legislation in a way that reflects their respective statutory roles. It is therefore a consequence of the Scottish Government Stage 2 Amendment, now Section 34A, and my Amendments 13 and 13A today. It allows the Commission and Commissioner to refer legislation directly to the Court for a decision on compatibility. This promotes legal clarity and certainty to the benefit of children and public authorities. It supports the Scottish Government's goal of clarifying and clearing up the statute book. I have made the positive case, but would encourage members to consider the consequences of not passing Amendment 14. The Children's Commissioner and SHRC have been advised that assessment by the Government is likely to be extremely time-consuming, that the Government cannot position itself as a source of legal advice to public authorities, and that it will only report to the Parliament where it receives a notification from a listed authority and where it proposes to take action. It cannot be left to children to bear the responsibility of clearing up the statute book, particularly when Part 2 would actively disincentivise them from raising actions they cannot benefit from. Instead, we should enable the Commissioner and SHRC to fulfil their statutory duties. And when organisations do want to challenge legislation without this amendment, the only route available to them is to identify an unlawful act by a public authority, bring proceedings, let the defence be raised, and then seek a determination from the court. That is adversarial, time-consuming and costly for all parties. Amendment 14 offers this alternative to take away that adversary, time-consuming and costly process. Amendment 15 requires a regular audit of legislation that is likely to require the UNCRC to be set aside, and requires the Scottish Government to state what they intend to do on finding any such legislation. This amendment would promote greater transparency and accountability by introducing a focused and systematic mechanism for identifying and addressing legislation that requires public authorities to act incompatibly with the UNCRC requirements. I note that the Scottish Human Rights Commission has suggested this at Stage 1 hearings, and it also has the support of Together. And so I urge people to support my amendments in this group. Thank you.
Thank you. I call Paul O'Kane.
Thank you, Presiding Officer. I would just briefly note that Scottish Labour will be supporting all amendments in this group. However, I would like to put on record that we remain concerned that there still hasn't been a coherent justification from the Government on why they felt the need to introduce the 6B exemption with such urgency in the parliamentary calendar, and what indeed prompted the need for it. Clearly something changed between the bill we considered earlier this session on reconsideration of incorporation that finally enacted UNCRC and now. And if nothing has changed, then it's even more inexplicable why these changes were not in the original bill and why indeed they are needed now. So given that lack of clarity, I think it's important that we have transparency and accountability over the use of a 6B exemption. I believe that all of the amendments in the group do strengthen that accountability and transparency, and so they will have our support. Thank you.
Thank you. And I call on the Cabinet Secretary to wind up.
Presiding Officer, I know that MSPs and children's rights stakeholders have called for safeguards in relation to use of the Section 6B exemption, and subject to Amendments 13 and 25 passing this evening, and with the existing powers available under the UNCRC Act, there will be a robust framework in place. First, a notification duty so that the Government, the Children's Commissioner and the Scottish Human Rights Commission are made aware when the exemption may be relied upon. Second, a requirement for the Government to consider and respond to those notifications. And third, an already existing route to test legislation to which the exemption may apply in the courts. Add to that our existing commitment through the Children's Rights Scheme to ask public authorities annually whether they are aware of any legislation that may be incompatible. These measures create a robust framework to identify potential incompatibilities early and enable the Government to consider whether action is needed. For these reasons, I move Amendment 25 and confirm that the Government supports Amendments 13 and 13A. I ask members to resist Amendments 14 and 15.
Thank you. The question is that Amendment 25 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division. Members should cast their votes now. The vote is closed. I call Shirley-Ann Somerville for a point of order.
Apologies, Presiding Officer, my app wouldn't connect. I would have voted yes.
Thank you, Ms Somerville. We'll ensure that's recorded. I call Keith Brown for a point of order.
Similarly, I would have voted yes, Presiding Officer.
Thank you, Mr Brown. The result of the vote on amendment number 25 in the name of the Cabinet Secretary is yes, 115. There was one vote against. There were no abstentions. The amendment is therefore agreed. I call amendment 13 in the name of Maggie Chapman, already debated with amendment 25. Maggie Chapman, to move or not move?
Moved.
Thank you. I call Amendment 13A in the name of Maggie Chapman, already debated with Amendment 25. Maggie Chapman, to move or not move?
Also moved.
Thank you. The question is that Amendment 13A be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 13A in the name of Maggie Chapman is yes 93, no 25. There were no abstentions. The amendment is therefore agreed. Maggie Chapman to press or withdraw amendment 13 as amended.
Press.
Thank you. The question is that amendment 13 as amended be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 13, as amended, in the name of Maggie Chapman, is yes 93, no 25. There were no abstentions. The amendment is therefore agreed. I call amendment 14 in the name of Maggie Chapman, already debated with amendment 25. Maggie Chapman to move or not move?
Moved.
Thank you. The question is that amendment 14 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 14 in the name of Maggie Chapman is yes 33, no 87. There were no abstentions. The amendment is therefore not agreed. I call amendment 15 in the name of Maggie Chapman, already debated with amendment 25. Maggie Chapman to move or not move?
Moved.
Thank you. The question is that amendment 15 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. I call Bill Kidd for a point of order.
Thank you, Rog. Sorry, wee bit Elvis there. Sorry about that. I would have voted no.
Thank you, Mr Kidd. We'll ensure that is recorded. The result of the vote on amendment number 15 in the name of Maggie Chapman is yes 8, no 91. There were 20 abstentions. The amendment is therefore not agreed. That ends consideration of amendments, and I suspend this meeting at this point for 10 minutes, and then we will move on to the debate. Thank you very much.